In the court, wrong seems to weigh in only when it can be proved or disproved in the language of evidentiary law. In the process, we find a legal system that is more faithful to linguistics than to justice. Pratiksha Baxi's Public Secret of Law is a thought-provoking and compelling ethnographic study based on rape trials in Western Indian state of Gujarat. Baxi unravels the way in which rape trials serve as a spectacle, where rape survivors are forced to bear witness to the reenactment of their own rape in front of the court. She highlights that the law is transformed beyond recognition by its localization, and what is revealed by the rape trial is not the gap between the law and its implementation, but rather how the law perpetuates phallocentric notions of justice. This book provides horrific insights into how rape trials in India become a pornographic spectacle, giving men pleasure while the survivor faces unbearable humiliation. Baxi's meticulous ethnographic study of rape trials in the rural district and session courts of Ahmedabad raises important questions about what constitutes justice for rape survivors. The book is an eye-opener for anyone who is interested in understanding how rape trials in India are conducted and how rape survivors are treated. The book has 5 key chapters that delve into different aspects of rape trials in India. The first chapter is a powerful exploration of the landmark rape cases, where Baxi demonstrates how the violence that underlies rape law jurisprudence is narrated away when the court appropriates the voices of raped women. The following chapters shed light on the different ways rape trials contribute to the production and re-entrenchment of phallocentric notions of justice, including how medicalization of bodies are used to determine truth and falsity of rape allegation, the split persona of child survivors of rape, and the culture of compromise that leads to acquittal of the accused. 5 key points from the book are: the book highlights how rape trials in India become a spectacle that gives men pleasure, while the survivor faces unbearable humiliation. The author argues that this spectacle reinforces deeply entrenched phallocentric notions of justice, which causes immense trauma to the survivor. One of the key points that the author makes is that language plays a crucial role in shaping narrative of rape trials. Official transcripts of trials are not verbatim, but rather contain only what the presiding judge deems important. As a result, the actual violence and brutality that takes place in the courtroom is often sanitized from the official record. This makes it easier for the precedents of injustice to continue, as there is little documentation of the reality of the trial. Furthermore, the language of the courtroom trial often use the prescribed narratives that may not accurately reflect their lived experience of trauma. The author argues that this results in legal system that is more concerned with linguistic accuracy than with justice. Another issue that the author highlights is the persistence of outdated medical jurisprudence text that perpetuates the stereotype of lying native women. This construct leads to a widespread distrust of rape survivors who are often seen as acting out of motives of revenge or compensation. The author argues that this distrust is built into the very architecture of legal system, making it difficult for the rape survivor to receive justice. Despite the deletion of Section 155(4) of the Indian Evidence Act in 2002, which enabled the defense to invoke the past history of women, it continues to inform rape trials in the courts of law. The book also shows that out-of-court settlements, though illegal, are routine affairs, enabled by delay in trial, lack of witness protection, and social stigma. There are 2 kinds of compromise cases. One where the survivor is pressurized by the lawyer and the accused to withdraw, and the other where the consensual relationships are turned into complaints of rape and abduction. Compounding this problem is the fact that rape is a non-compoundable offense, meaning that it is illegal to compromise or settle a rape trial. However, author argues that the courts routinely dismiss case or reduce sentences based on production of stamp paper indicating that victim has reached a compromise. In many cases, the courts do not even investigate the circumstances of such compromise, leading to a situation in which social norms are prioritized over legal justice. The book argues that when a Dalit and tribal woman are raped, judges rarely see the context of caste and tribal violence. In those rare instances where the rape as atrocity is recognized, it is seen as an exchange of violence between men of unequal status. More often, complainants are seen as liars who have pressed false charges to seek compensation under Prevention of Atrocity Act 1989. Baxi's ethnographical approach to trial court process is enlightening and eye-opening, as she explores how rape trial produces theatrical space where public secrets about rape are produced, negotiated, and managed. She exposes different ways in which trial reenacts the rape and how rape law precedent, far from stating in what instances a rapist should be convicted, actually determines in what instances rape survivor should be believed. Why should one read this book? It provides unique and critical insight into legal system's shortcoming in dealing with sexual violence in India. It highlights the way rape trial perpetuates the patriarchy and how court fails to provide justice to survivors of sexual violence. Baxi's book is a powerful and insightful critique of criminal justice system's treatment of rape survivor in India and is an essential reading for anyone who is interested in understanding how rape trials in India are conducted and how rape survivors are treated. Reading Public Secret of Law raises the question how we can change the way sexual violence is dealt by the law. It prompts to consider alternative approaches to legal system that prioritize survivors' experience and bring about more just and equitable society. How can we reform the criminal justice system to better serve the rape survivors? How can we change deeply entrenched fellow-centric notions of justice? And what can we do to ensure that rape trials do not become a pornographic spectacle that gives men pleasure while the survivors face unbearable humiliation? In conclusion, this book has successfully demonstrated how ethnographic studies of trial can provide us valuable insights into actual practices of law and how it differs from doctrinal law. By exploring the nuances and interactions between judges, lawyers, witnesses, litigants in the courtroom setting, the author has revealed how the spoken law often deviates from legal principles enshrined in written statutes and judgments. As legal professionals, it is important for us to be aware of these differences and to strive toward bridging the gap between the two. This is where the platform like Bar and Bench become invaluable in bringing accurate and timely updates from courts around the country. So do visit our website, link is in the description box, and do not forget to subscribe to our channel Bar and Bench.
Subscribe to our YouTube channel and click the bell icon.